Good evening and a very warm welcome to this webinar, which is on costs in financial remedy proceedings. My name is Hannah Justiva and with me is Andrew Pote. We are both barristers at 42BL Barristers and we both specialise in financial remedies as well as private children law. This is the fourth session in this series of family law webinars. All previous recordings and sign-up links can be found on our website. If you have any questions, we'd be grateful if you could please put them in the Q&A, and these will be addressed at the end of the session, time permitting, or we will follow them up via email. If you are watching the recording, please send your questions to events@42br.com. An email containing the recording, our slides and a feedback form will be circulated in the next few days. So as mentioned, this webinar is all about costs in financial remedy proceedings. And I just want to begin with setting out the framework for costs in family proceedings generally. So we have Section 51 of the Senior Courts Act 1981, which provides that the court, in terms of costs, it's at the discretion of the court. So it's extremely discretionary in terms of the power as to costs. Now, in terms of the framework for procedural rules to assist us with determining issues around costs, it's important to emphasise that although we are concerned about costs in family proceedings, we are using both the civil procedure rules and the family procedure rules. In terms of the family procedure rules, I'm sure you'll already be familiar with parts 28 and practice direction 28. And what that does is it incorporates the rules on costs from the civil proceedings into the family proceedings, but of course, very significantly, it does disapply a small number of the above rules. But to emphasise, the other rules within parts 44, 46, 47 and rule 45.8 still apply and are still relevant and ones that we need to know. So in terms of the no order as to costs principle, this comes from the Family Procedural Rules and is rule 28.2. And it's extremely important because this disapplies the rule that is used in civil proceedings that the unsuccessful party will be ordered to pay the costs of the successful party. And the no order as to cost principle applies in terms of the substantive financial remedy proceedings, whether it's marriage or civil partnership, variation applications, and the substantive proceedings in terms of a Part 3 application. But of course, to remember that although the costs following the event rule doesn't apply, the other parts of the CPR in terms of costs will continue to apply. When considering the no order as to cost principle, of course, there is effectively an exception to this, and that's in terms of conduct. The court can still make an order for costs even when we're concerned with the no order as to cost principle, because of conduct. And when I'm talking about conduct, I'm talking about litigation misconduct as opposed to personal misconduct or other types of conduct that we might be talking about in financial remedy proceedings. The guidance of the kinds of things we would need to look at comes from Rule 28.3 and subsection 7. And it sets out the kinds of things that may fall under litigation misconduct. So the first one there in that slide is A, so any failure by a party to comply with these rules, any order of the court, or any practice direction which the court considers relevant. Now, the kind of example that you may and probably will have come across, maybe you're at a first appointment and the other side has not engaged, they haven't completed their Form E. So clearly they haven't complied with the order and rules, and therefore it would very likely be appropriate that a costs order needs to be made due to that. But it's important to consider the other provisions which may mean that it is appropriate for there to be an order for costs. So on this slide, you can see the relatively new provision is a failure by a party without good reason to attend a MIA or NCDR, so that's non-court dispute resolution. This is something that's really being increasingly subject to quite a lot of focus and attention in terms of the importance for parties to engage with NCDR. There is, of course, the FM5 that needs to be completed, and that's a really helpful example to show to the court what steps have been taken and what effort has been made to try and resolve the issue between the parties without having to apply and make the application. Having said that, I don't think I've certainly not had a judge so far say that they're going to make an order for costs because a party hasn't effectively engaged with NCDR. But I think it is really important to warn clients that they may well face an order for costs if they don't do this. And therefore it's important we're making sure we protect clients in respect of that. The next provision is in terms of any open offer to settle made by a party. So to emphasise, we're looking at open offers rather than without prejudice offers. There's also the point about whether it's reasonable for a party to raise, pursue or contest a particular allegation or issue. The kinds of things that might arise in respect of this rule maybe, for example, a party wants to pursue a conduct argument, so a personal conduct argument that just really doesn't have any merit. Of course, you would try and get that addressed at the first appointment, but if the court does permit conduct statements, you will obviously have incurred the cost of having to respond to their conduct statement, and it may well be that it is appropriate for an order for costs to be made in terms of the cost that you've had to incur to respond to that, and that it wasn't reasonable for them to pursue that allegation or that point. There's also the manner in which a party has pursued or responded to the application or a particular issue, any other aspect of a party's conduct in relation to proceedings. So again, we're looking at litigation misconduct. And then finally, the financial effect on the parties of any costs orders. Now, we're going to turn to the case law shortly, but of course that remains a really relevant and important factor for any judge. That even where there has been difficulties in terms of litigation misconduct, they are still required to consider the effect that any costs order would have upon their finances. The additional guidance comes from the practice direction. So the paragraph that's relevant for us is 4.4. I've only quoted part of it, and it's really just to emphasise two things in particular. One is if you're dealing with an application to vary, so for example, to vary a maintenance, so periodical payments order. The problem is that often such applications are disproportionate, and therefore, if you like, you are at additional risk in terms of costs, because of course it's really important that any litigation, particularly on a variation application, is pursued proportionately. So that's just something to really bear in mind if you're dealing with that kind of application. The second part is the emphasis in terms of the court will take a broad view of conduct for the purposes of this rule and will generally conclude that to refuse openly to negotiate reasonably and responsibly will amount to conduct in respect of which the court will consider making an order for costs. And it makes clear even in the practice direction, this includes in a needs case where the applicant litigates unreasonably. So it's there in the practice direction itself that it's extremely important that parties first and foremost are making open offers, but also that those open offers are reasonable, because otherwise they are potentially at real risk of costs. In terms of the case law, there has been a real shift, I think it's fair to say, in terms of an increased willingness that the courts will make orders for costs. So, for example, we can see this in OG and AG 2020. This was a case by Mr. Justice Mostyn, and he said, "It is important that I enunciate this principle loud and clear. If once the financial landscape is clear, you do not openly negotiate reasonably, then you will likely suffer a penalty in costs. This applies whether the case is big or small, or whether it is being decided by reference to needs or sharing." And this is something that Mr. Justice Peel has built upon. So in WC and HC 2022, he says, "It is, in my view, important for the parties to be aware that even in needs-based claims, no litigant is automatically insulated from costs penalties." And again, another case by Mr. Justice Peel, HO and TL 2023, the authorities make plain that a costs order may be made even if it reduces the needs as found by the court. And he emphasises this applies particularly to big money cases, but also is relevant to smaller value cases. And he says in the right case, it may be appropriate to make an award for costs, even if only in a modest amount, to register condemnation of the party whose open proposals are far removed from the eventual outcome. The message must get across that although the starting point is no award for costs, the courts are increasingly willing to depart from that so as to do justice to the party who has been put to unnecessary costs by the other party's overstated proposals. In practice, I think what this really means for us when advising clients is, first and foremost, it's extremely important to make open offers. It's for a long time now, we've had the provision that after the FGR, within 21 days, we need to be making open proposals. Of course, that timescale can be varied by agreement, but what I would certainly urge against is waiting to make an offer that is open until just before the final hearing. I think if a party does that, they're always at an increased risk of being on the receiving end of a costs order, especially if the other side makes an open offer earlier on in litigation. If the other side does make an open offer earlier on in litigation, I think really you need to be seriously considering, first and foremost, you need to respond to that. But secondly, making your own open counter offer and also being more willing to make open offers earlier on within the litigation, perhaps even prior to the FGR appointment. And the second part of that is not just to make the offers and to make them promptly, but also to make sure they are reasonable and that they are something that can be defended. Because if they are something that's just simply isn't within the boundaries of what the court would likely do, that they may well find they are subject to a costs order. So it's very important to be aware of. I'm going to hand over to Andrew, who's going to deal with the clean sheet rule.
Thank you very much, Hannah. Yes, I'm looking at applications that are outside the general rule that the court will not make an order requiring one party to pay the costs of another party. And of course, these cases involve things which take part within financial remedies proceedings. And we're looking at those in a moment. The Schedule 1 of the Children Act 1989, they are excluded because, of course, they're in a separate category. They're under a separate act, obviously. And also, normally, unless the child has got permission to bring the application themselves because of their age, then they are brought by the parent, normally with the care of the child, on their behalf. So I'll refer to that a bit later on when we look at the clean sheet rule in practice. Maintenance pending suit and application for interim periodical payments, they are outside as well. And that's very important because maintenance pending suit applications are supposed to be applications which were originally supposed to be dealt with as a broad brush preliminary issue, very much on the papers, no oral evidence, and where the parties are encouraged as far as possible to make proposals and to come to an agreement, because of course an order is supposed to deal with meeting urgent needs. An interim order, a legal services order and or cost allowance, of course those orders have become more popular. Section 37 freezing orders and setting aside a transaction. It's important to note the case law on when it's appropriate to make an ex parte or without notice Section 37 application, and when the court is likely to make one, and bear that in mind when you're considering the question of costs. Setting aside of a financial order, rather than appealing it, setting it aside for some intervening barter event or something like that, or a mistake or fraud or non-disclosure. Permission to apply under the MFPA 1984 Part 3, of course, for financial relief involving a divorce overseas. And appeals. Appeals are a completely different category, of course, because appeals against financial orders are outside of the scope. It's important to note when advising clients on appeal that the court, although if appeal permission has not been granted from the trial judge, and it's very rare that it is, of course, permission is required from the appellate court. And the judge will normally do that, or should do that, first instance, looking at the appeal on the papers. But looking at the grounds of appeal and the skeleton argument in support of the grounds of appeal, comparing it against the transcript of the judgment or the note of the judgment. What's happening more frequently is that judges are deciding to require a response to the permission to appeal application and skeleton argument by a skeleton argument from the respondent to the appeal, and then listing the hearing for permission to appeal hearing with appeal to follow if permission is granted. That, of course, means that the respondent has to attend if they're contesting the appeal. And of course, that leaves the appellant open to pay the respondent's costs for the skeleton argument and for attendance and preparation if the appeal is not successful or permission indeed is not granted. And of course, you have to be concerned that an appeal may still at that stage be on the basis that permission is then refused and it's deemed without merit. And therefore, that could lead to costs being dealt with on an indemnity basis. And we'll deal with that later on in the talk. Proceedings that are not for financial orders, but are about or in connection with financial proceedings, are also outside of the general rule of no order as to costs. And those include challenging an arbitration award. Now, that you'll be aware perhaps that there have been a few cases where, notwithstanding that the parties have agreed to arbitration, when the order has been sent to the court by one party to have it confirmed as a consent order, the other party have tried to challenge it on the basis of some procedural irregularity or mistake of law, whatever. And in those circumstances, those are outside of the no rule cost rule principle. Of course, civil proceedings being heard together with financial order proceedings, which sometimes can happen, those civil proceedings would be subject to the civil procedure rules and therefore would be subject to the rule that the unsuccessful party usually pays the costs of the successful party. Contempt proceedings and other enforcement proceedings are outside the rule, as are costs involved in interveners being involved and other preliminary issue applications. This is important as well when looking at the question of an intervener being involved. Now, there's case law that says, and it's been present for a long time, that preliminary issues involving interveners should be dealt with as early as possible in the proceedings, normally before the financial dispute resolution appointment. However, some judges have been reluctant to do this and have made orders that the intervener gets involved in the financial dispute resolution appointment in the hope that the case will settle then and everybody will be able to sign up to a consent order. Now, sometimes that is possible, but it is less likely to be possible where there is a binary issue as to whether the preliminary issue is a yes or no. For example, is the loan that somebody is relying upon to a third party a true loan, or is it a sham? Well, there's really no intermediary part on that. It either is or it isn't. So when there are clear issues like that, it will save costs, possibly, if it is dealt with as soon as possible as a standalone preliminary issue, because costs are payable to the intervener if the intervener is successful by the party or parties that don't agree with the intervener's position. And of course, if one spouse is supporting the intervener's position and one isn't, then the one that isn't can also be liable for the other party's costs as well as the intervener's costs. So that needs some careful thought when dealing with those types of cases and pushing for early resolution of the preliminary issue that the intervener is concerned with. So then they are taken out of the proceedings and their costs won't be as much if they have to carry on and be involved in a final hearing. Also, setting aside applications and striking out applications, which of course are quite rare, but those are outside the general no order rule as well. Now, what does the clean sheet rule mean? Well, technically it means that neither the general rule of no order or the usual civil rule that the loser pays the winner's costs don't apply. Now, it has been looked at and is held that the civil rule should apply in proceedings not covered by the general rule in financial proceedings, except Schedule 1 Children Act. And that's the case of KS and ND, Schedule 1 Appeal Cost 2013, where the court should start with a clean sheet. But nevertheless seem to imply, and this was a case which again was dealt with by Mr. Justice Mostyn, it involved appeal against a costs order and in regards to a finding about the payment of school fees, which the mother appealed against. I won't go into the facts, but Mr. Justice Mostyn was concerned about the high level of costs on both sides, which were disproportionate to the amounts of money that were being argued about in the appeal itself. Other factors to be taken into are the conduct of the parties, the success or partial success of a party, admissible offers, and we'll look at that in a moment, and also disparity of the parties' means. And of course, referring back to the general power which the court has under the Senior Courts Act to make such costs order as it thinks just. So there is a lot to argue about when it comes to costs which are being sought in cases where the no rule doesn't apply.
Okay, so now if you've been able to get your order for costs, you've successfully persuaded the judge there should be the order for costs. The question then becomes, how do you actually assess how much of your costs you should get? There is summary and detailed assessment, and I'm just going to take you through each of them. Beginning with summary assessment, for this we do have to look to the Civil Procedure Rules, and it's Part 44 and Practice Direction 44. And summary assessment, I suspect, is by far and away the assessment that you would want the judge to take. What it is where the court orders a payment of a specified sum of money assessed at the conclusion of that hearing. So in the way you would expect, whether it's at the end of a first appointment, for example, if someone hasn't completed their Form E, or whether it's at the end of a final hearing after judgment, that the judge will hear submissions and then make the order for costs and specify exactly how much should be paid. The absolute golden rule, and one of the things I would hope everyone's already doing, but if not, please do file and serve the N260 not less than 24 hours before the hearing. If it is filed after that time, the court does not have to make an order for costs and can actually refuse to do so. And that is something that I have seen happen. So please make sure that you don't fall into that trap and that it is done on time. The other thing just to bear in mind in terms of summary assessment is that it might not always be an option. So where a party is legally aided or a party is a child or a protected party, just be mindful that this may not be an option available to you. The obvious benefit of summary assessment is that you get it done and dusted at the same time as the hearing. You're not having to come back for a further hearing to deal with the question of costs. There's also, if there is an order for costs, generally it would need to be paid within 14 days, and I would make sure that you also get that specified in the order in any event. So then the question turns to what is detailed assessment, which I suspect you've probably come across less frequently. So detailed assessment is found within Part 47 and Practice Direction 47 of the Civil Procedure Rules. And it is your comprehensive guide as to how to deal with detailed assessment. Generally, detailed assessment would only take place after the conclusion of the proceedings. Not necessarily, but generally it would be after the conclusion of proceedings. If you get an order for costs to be subject to the detailed assessment, the person who is receiving the costs order must, within 3 months of that final order, issue a notice of commencement, which is the form N252. Along with that form, you must also attach a copy of the bill of costs, copies of fee notes of counsel, of any experts in respect of fees claim, written evidence of any disbursements which is claimed and exceeds £500. So you have to make that application. Then what happens is the person who is paying the costs must, within 21 days of being served with that notice of commencement, set out any points of dispute, so points of dispute in respect of the costs that are being sought. The receiver of the costs does have the right that within 21 days of being served with the points of dispute, they can reply to those points. Now, be mindful that if you don't complete points of dispute, the other side has the right to apply for a default cost certificate. So it's extremely important that points of dispute are put forward if you do contest the costs being sought. Normally, parties would seek to agree the costs because of the obvious issue of having to have the expense of a further hearing. And if they are agreed, either party may simply apply for a cost certificate in the amount agreed. If, however, the costs are disputed, the person who's receiving the costs order must complete an N258 requesting a detailed assessment hearing, and that must be done within 3 months of the date when the expiry period for commencing detailed assessment proceedings ended. So I hope that's helpful just to take you through the structure of what you would follow if you ever were in a situation where you're having the detailed assessment as opposed to summary assessment. But as I say, I would normally always try and get summary assessment if possible.
Now we look at the basis on which the assessment takes place, whether it's being done summarily or on detailed assessment. There are two bases. The first is the standard basis, which I've called the normal basis. And these are costs that are proportionate and reasonably incurred. Only those costs will be allowed. And that they are proportionate and reasonable in the amount. And any dispute is resolved in favour of the payer. Now, this is why it's very important in the N260 if you're going for summary assessment. And I echo what Anna has just said, because the court in Q&Q, Family Division Costs, in 2002, said that detailed assessment is counter to the satisfactory resolution of a dispute at the end of the hearing. So to prevent things dragging on and there being uncertainty with the financial position of the parties, summary assessment should be the correct way forward. And it's important, therefore, to make sure that all the information is there to allow a proper summary assessment to take place, and of course, for arguments to be made to challenge the amounts being claimed. The second basis is the indemnity basis. And this is in cases where the payer's conduct has been highly unreasonable. And this differs in two ways from the standard basis. There's no requirement for proportionality, and any dispute resolved in favour of the payee rather than the payer. Now, indemnity basis has been in the past quite rare. I've had one recently in the last 12 months, but only one. But with certain requirements now enshrined in the FPR and case law, they may and are probably becoming more common. And of course, it's worth bearing in mind that repeated failures to comply with the rules and court orders can lead to highly unreasonable conduct. And so in those circumstances, it's important to look out for that. Of course, as it stands, there's no way that the costs between a party and their solicitor can be regulated, because if the party agrees to pay them, then of course they are payable to the solicitor. But that's why, importantly, the court must look at the Form H's as well to consider the amount of costs that have been claimed or charged so far, the estimates, and what has been paid. Because obviously, in certain cases, the amount of money that's being claimed has to bear some reasonableness to it. And overall, not in terms of the basis that's being applied, whether that is reasonable. And when it comes to rates of hourly rates being claimed by solicitors, there's no set rates like as in civil procedure or guidance in civil procedure, but those have been in some cases held to apply. So it's careful to consider the hourly rates that are being charged, and that there isn't duplication of work being carried out in terms of the matters that are being claimed.
Okay, so moving on to security for costs. Now, this is quite unusual, but it is interesting to consider and may well crop up in your practice. The rules in respect of security for costs is from Family Procedural Rules, and we're looking at Rule 20.6 and 20.7. So 20.6 tells us, and this is only applies when you are the respondent. So a respondent to any application may apply under this part for security for costs of the proceedings. So where the court makes an order for security for costs, it will determine the amount of security, and direct the manner in which and the time within which the security must be given. 20.7 sets out the circumstances of when an order for security of costs may be made. There are gateway criteria, if you like, that you have to be able to satisfy in order to be able to make the application for security of costs. So obviously you need to be the respondent, and then you need to satisfy one of the following four. So firstly would be the applicant is resident out of the jurisdiction. Secondly, the second one, the applicant has changed address since the application was started with a view to evading the consequences of the litigation, or the applicant failed to give an address in the application form or gave an incorrect address in that form. Or the fourth is the applicant has taken steps in relation to the applicant's assets that would make it difficult to enforce an order for costs against the applicant. So you have to satisfy one of those four conditions. In terms of how we approach security for costs within family proceedings, these are the two cases that I would encourage you to look at. So you have the case from Mr. Justice Mostyn for MG and AR 2021, but you also have the case of Mr. Justice Cobb L&O from 2024. And what's particularly helpful in respect to Mr. Justice Cobb's case is it dealt with a barter application, so you can see how this may apply within financial remedy proceedings. Now, I haven't put the cases in great detail, or really any detail on the slides, because it's quite extensive, but I just wanted to take you through in particular what Mr. Justice Cobb has said in respect of security for costs. So he says within the judgment that the applications for security for costs in family proceedings are relatively rare. And the obvious reason for that is because of the general rule of no order for costs in family proceedings. However, of course, in that case, he was dealing with an application under the barter jurisdiction, and therefore it fell under the clean sheet rule. And he described it as being more akin to a civil action. And that the general rule, there'll be no order for costs, is expressly disapplied in relation to a barter application. He says the purpose of an order for security for costs is to protect a party in whose favour it is made against the risk of being unable to enforce a costs order which she may later obtain in the proceedings. And he explains, as did Mr. Justice Mostyn in his judgment, it's essentially a two-stage process. So the first stage is, do one of those 4 gateway provisions apply? And that's a question of fact. The second part of it is to exercise a value judgment and discretion. For example, whether it is just to make an order in all the circumstances, given the strength of the claim, defence, and the financial positions of the parties. Now, Mr. Justice Mostyn emphasised that it would be incumbent on a court to carefully consider the merits of the case. Though, of course, when dealing with a barter application, the rule that there's no order for costs expressly doesn't apply. So Mr. Justice Cobb felt that he did need to go into that specific consideration. But obviously what he still needed to do was consider whether it's just ability to pay, the level of risk that the wife in that case may not be able to enforce a costs order, whether the application was made promptly. To give you an idea of when you might need to be thinking about, should I be making an application for security for costs, when might it be helpful? In that case, it was the husband was deemed not to be resident in the jurisdiction, and the assets that he had were mainly held abroad, and there had already been difficulties with enforcing any order, enforcing the judgment in the financial remedy proceedings, and she'd actually already taken enforcement action against the husband. And the court held that he had sufficient resources to be able to pay for security of costs. So that's the kind of case in which this may be relevant and something you need to consider.
I'm just going to turn now to Calderbank offers. What is a Calderbank offer? Well, it means a written offer to settle a case or the element of a case marked without prejudice save as to cost. So called from the Court of Appeal case in 1975 of Calderbank and Calderbank. This was very much before the no rule principle was introduced, the way of seeking costs at the end of a financial remedies case, and of course talked about as ancillary relief. But of course that's changed now in terms of the criteria that's set out for an exception to the no rule in financial proceedings that we've heard about from Hannah earlier, when we heard about a reference to an open offer. And now normally a without prejudice offer is seen only in financial remedy proceedings at the financial dispute resolution appointment stage. By definition is not an open offer to settle, so that cannot be referred to costs in cost hearings in proceedings for financial orders covered by the general rule, but can be referred to in cost hearings in cases which are not covered by Family Procedural Rule 2835. And so it is important to note that this distinction when advising a client to make an open offer and when to make a without prejudice offer, save as to costs offer. Now, we do see still in financial remedy proceedings, without prejudice as to costs being stated at the top of a letter, even after the FDR stage, and with regards to correspondence going on and attempts to settle the case. But of course, they're not open offers, so cannot be referred to, as I've said. But where we are dealing with something which is in connection with or in the proceedings, a preliminary issue or an application for something within the proceedings, then of course it's important to try to negotiate and to settle rather than to bring the matter back to court. And of course it's very important that the parties seek to do that, so that then if there is necessary court hearing, then an application for costs is likely to be more successful if you can show evidence that you've done your best, either on an open basis or with an out prejudice basis, to try to settle the matter. But there seems to be still some confusion in people's minds about when it is appropriate to do without prejudice, save as to costs correspondence, and when it's not. But there can be no doubt that only the open offers will go to those cases where they are covered by Rule 2835, but they can be used in other cases. And so in those circumstances, as I say, it's important to be aware of which proceedings you're dealing with and which of the cost rules apply and which of those do not apply. And one of the things that we haven't mentioned on the slide or in the talk is, of course, just the warning that the Civil Procedure Rule 46.8, which deals with wasted costs against legal representatives, has not been disapplied in financial remedies. So it is there, as of course is the power under Section 51(7) of the Senior Courts Act 1981. So wasted costs are way of also, of course, where cost orders will be made and met, which of course doesn't take away from the parties' award or what they've been seeking to achieve in terms of the application that they've made. Thank you.
Thank you very much. Well, I don't think we have any questions, but obviously if you do have any questions, please do email them to us. I think it's at events@42br.com. Just to emphasise, the recording will be available on our website and YouTube channel shortly, and we would be very grateful for any feedback. The next session will be taking place on Thursday, the 8th of May, in which Sharon Smith and Krishma Patel will present a practical approach to pre- and post-marital agreements in financial remedy proceedings.
So thank you very much for tuning in to listen to us and enjoy the rest of your evening. Thank you.